Strata Bites, your Strata update, with Rob Lalor and Frank Higginson from Redchip Lawyers.
For those of you that have been following what's been going on in state government and the property law review, Queensland is about to have its single biggest piece of property law reform in 50 years. The Property Law Act from 1974 is being repealed and replaced with the Property Law Act from 2023. And that's right, that's 2 years ago that it was actually passed. So there's been 2 years worth of working with community, planning implementation, coming up with forms, and getting everyone ready for something that arrives on the 1st of August 2025. So it's designed to create a more vendor disclosure regime. So you would have heard the phrase caveat emptor before. That means buyer beware. The Queensland system is moving more towards a seller disclose arrangement, which means that all sellers of properties in Queensland are going to have to tell the buyer what they're buying. And so for those of us that have been around for a little bit longer, it's oddly reminiscent of what might have happened in the run-up to the GFC in 2008. So this is all about consumer protection, and under the Property Law Act, and I suppose the Property Agents and Motor Dealers Act, in that regime, the consumer protection had, I suppose, in a sense, some unintended consequences.
It did, and I think the main thing I sort of think about is the fact that these disclosure regimes work really well when a market's going really well, but when that market starts to dip, then lawyers like you and me start to look for reasons why or reasons how we can get out of contracts. And most of those typically come back to technicalities, and when you have consumer protection mechanisms in place, it allows you to review your contract through the lens of that legislative regime, and it gives you sort of broad rights of termination, which obviously leads to disputes and a lot of uncertainty in what is a tightening market.
Yeah, and it's interesting when things are booming, no one cares. When things turn and people look at a contract and decide, actually I don't want to do that deal anymore, and they turn to their lawyer and say, hey, get me out of this, what do you do? And that's what this disclosure regime changes. So the way that contracts were prepared previously, in terms of agents preparing them, sign a copy, away you go, and the buyer do all their searches later on, is not going to be the safe bet anymore. So not trying to take work out of agents' hands. If they want to do it, go for it. But I think from a seller's perspective, if you want to make sure that you've got a watertight rockstar contract, and I suppose, if you're settling in 30 days' time, it might not matter. But if you're doing a 90-day deal, positions for buyers can change. Their finance might change, bank rates may change, bank policies may change, their business might be, whatever it is, that means that they might not be in a position to settle. You've got to be really careful with this stuff now.
And that's the reality of it. So we do have a situation where you've got a fairly new regime coming in place where not many people really know what's going on. This new legislation's been floating around for a good couple of years now, but it's come up to 1 August, and we're talking to our search providers and the other sort of contractors that we use in the marketplace to help us get this information together. And it doesn't feel to us like there's a great deal of preparedness for it. We talk to a lot of agents, in particular around this new regime, and up until about a month ago, it would be 1 out of every 2 that didn't even know that this legislation was coming up. Yeah. So it's going to be an interesting few months. We think it'll be probably a little bit more of a ripple than a big wave, but that big wave will come when, and I say when, but if the market turns in the other direction, and that's when, we're probably putting this more towards our sort of agent relationships. That's when your commissions are going to be at risk, because you're going to have these deals potentially fall over, or at the very least become really elongated because you're just not complying with your legislative requirements.
Yeah, and I think if you probably go back to political phrases, it's be alert, not alarmed.
Yeah.
So it is something to be very wary of, because this starts in a week's time. So really, it's a matter of making sure that you really do dot your I's and cross your T's with disclosure from then, because if you don't, that's the risk you're running.
Correct.
So Rob, what's next for property sellers then?
Look, I think it's really a case of being aware of what your obligations are and understanding that you've got really what are now heavy rights as a vendor to all your buyers, and if you don't get this right, you're leaving the door open for a buyer to walk away from your contract. So I think if you've got something that's about to go into contract, feel free to give us a call if there's any queries or other concerns you might have about the information you need to disclose as part of this regime. It's going to be hugely important if the market turns. But while you've got buyers that want to buy and sellers that want to sell, life's probably not going to be too bad. It's as I say, when that market turns, you've got longer term deals where the sentiment changes, where you're going to start running into technical issues around these sorts of contractual requirements and legislative requirements.
Makes sense to me, mate. Absolutely.